Hi, this is Ramya Ravindran and welcome back to my channel Infinity for UPSC. Today we are going to discuss a topic called President's Veto Power. Now why did I choose this topic? Because since last two videos we have been discussing about a bill becoming an act with the assent of the President. That is, when the bill reaches the President, he gives the assent and then makes the bill an act. Now, does he give the assent always? No, he has got some other options as well. So in this video, we are going to see all the options that the President has when a bill comes to him. A bill passed by the President can become an act only if it receives the assent of the President. We know this already. When such a bill is presented to the President for his assent, he has three alternatives. And these alternatives have been provided to him under Article 111 of the Constitution. Now again, a very easy article to remember. In the previous video, we had discussed about ordinance and I told you the article number is very easy to remember. I hope you remember that article. It was Article 123 that was associated with ordinance. Now here we see another article which is easy to remember, Article 111, which is associated with the options that the President has when the bill reaches the President for his assent. First alternative is he may give his assent to the bill. That is, he said yes to the bill and the bill has now become an act. Second option, he may withhold his assent to the bill. That is, he is not saying yes to the bill. That means this bill will be dropped here itself. It will not go on to become an act. Third one, he may return the bill. Now return to whom? Return to Parliament. That is the place from where the bill originated. It will be returned back to that place for reconsideration. Now when will this scenario happen? Reconsideration. Here the President is okay with everything about the bill. So he says yes. Here he did not like the bill. So he says no. Here he is okay with the bill, but there might be some clauses which he is not okay with or which he doesn't agree with. So in that case, he will send back that bill again to the Parliament for the reconsideration so that they can look into the bill and make some changes which were not acceptable to the President. Now, what does this mean? That means he is not rejecting the bill in its entirety. There are only few clauses which he is not agreeing with. I hope you know that whenever there is an act, we see that act number or article number so and so, and there we will have many clauses, clause A, clause B, clause C, and within each clause we will have sub points. That is article so and so, clause number A, point number 1, 2, 3. So there would be many clauses and sub clauses which he might not be agreeing with. So in that case, where he is not rejecting the bill as a whole, but only few aspects needs to be changed, he will give it back for reconsideration. Now the another point that you need to remember here is that all bills cannot be returned to the Parliament for reconsideration. He cannot return a money bill. Here we were talking about ordinary bills, but there is another category of bill which is called as a money bill. And if it is a money bill, he cannot return the bill. He has got only two options, either to give the assent or to withhold his assent. He cannot return the bill in case of money bill. Now again, the types of bill, this is a new topic for you, new terminology for you. So I will be taking another video. I will be discussing all types of bills in that video. So there I will be explaining you the ordinary bill, the money bill and the other bills that we have. So all types will be discussed there. As of now, just understand that we are talking about ordinary bill and there is something called as money bill which cannot be returned. Now, after the bill has been returned to the Parliament, if the bill is passed again by the Parliament with or without amendments and again presented to the President must give his assent to the bill. Now, why did he give it back to the Parliament? He wanted some changes to be made in that bill. That is, some amendments. Amendments means some sort of changes, some changes to be made in that. So, when he returns it to the Parliament has also got two alternatives. Either the parliament can make some changes and present it to the president again, or the parliament can choose not to make any amendments and keep the bill as it is and present it to the president once again. So parliament has also got two choices, that is to make amendments and to not make amendments. Now how do they present it again to the president? Parliament will have to go through the procedure again. They will have to put the bill to vote once again in the house where it originated and in the other house. So both the houses will vote once again, and if the bill is passed once again, they will present it to the president. Now when the president gets the bill for the second time, that is it has been passed twice by the parliament, now he doesn't have any options but to give his assent. That is, he will have to say yes to the bill. Thus, the president has veto power over the bills passed by the parliament. That is, he can withhold his assent to the bill. What is a veto power? Veto power usually means a power possessed by a person who can single-handedly block a decision which has been taken by a group. Now here what is happening? The parliament as a group has taken some decision, but president single-handedly can block that decision of the parliament. So we say that he has got some veto power over the bills passed by the parliament. Now what are the objectives of conferring this power on him? There are 2 points. One, to prevent hasty and ill-considered legislation by the parliament. Hasty in the sense, a decision made quickly without giving much thought into it. Ill-considered means it has not been considered properly, not been discussed properly, or it has been discussed incorrectly, not in a correct manner. So these kind of mistakes can be avoided by the president. Second, to prevent a legislation which may be unconstitutional. Now there is one more point that you need to remember. Whenever a new bill is proposed, it has to be made sure that the bill is in line with the constitution. That is, it is in sync with the constitution. If that is not the case, the bill will not be passed and it will not be made into an act. And even if that bill has been made into an act by parliament, the judiciary comes forward and it can strike down such an act, saying that it is unconstitutional. So it is good that you do not make any law which is unconstitutional, because anyway it is going to be struck down by the judiciary. So in order to avoid these two mistakes, the president has been given the veto power. The classification of veto power. The veto power enjoyed by the executive. Again, we have discussed executive means the elected ministers. Executive in modern states can be classified into 4 types. Absolute veto, qualified veto, suspensive veto, and pocket veto. So these are the 4 types of veto powers which are there in the modern scenario. But have we got all these 4 kind of veto powers when it comes to Indian president? No. Indian president has got only 3 veto powers, that is absolute veto, suspensive veto, and pocket veto. Which is the one that we do not have? Indian president doesn't have the qualified veto. Except this, all 3 veto powers are available with the Indian president: absolute, suspensive, and pocket. First one, absolute veto. It refers to the power of the president to withhold his assent to a bill passed by the parliament. That is, he is not giving his assent, he is not saying yes to the bill. What will happen then? The bill then ends and does not become an act. So the bill is dropped then and there itself. Usually this veto is exercised in 2 cases. One, with respect to private member's bill. Who is a private member? Now this was asked in your UPSC prelims. It is a very important statement. Listen to this very carefully. Who is a private member? Now a private member is a person who is a member of parliament, but he is not a minister. Looking at this term, there are students who would think that private member means he is not associated with government in any way. He is not even member of a parliament, but he is some outsider. That is not the case. He is very much the part of the parliament. He is the member of parliament, but just that he has not been elected as a minister. So a private member's bill can be withheld by the president. This is absolute veto. What is the second scenario? The president can withhold his assent when it comes to government bills. Government bill in the sense, bill which has been proposed by the member of government, that is government itself. Now why would president withhold his assent which has been proposed by government? There is a special scenario here. This can be done when the cabinet resigns. That is, when the government no longer exists. In that case, the government bill can be withheld by the president. What is the meaning of cabinet? Cabinet means the ministers who are heading different ministries or different departments. We know that we have got different ministries and different departments. All these are headed by some or the other minister, elected minister. And that group is called cabinet. So when the elected ministers are resigning themselves, there is no point in passing the bill which has been proposed by the government. That is, government itself is going to change. Now when does this scenario actually arises? This arises when it has been passed by the parliament, but by the time it has reached the president or by the time he can give the assent to the bill, the cabinet has already resigned. So the bill has been passed, but it did not get the assent of the president. Meanwhile, the cabinet resigned, and now the new cabinet which has arrived, that new cabinet advises the president that you are not supposed to give your assent to this bill. So what is happening here? The new government has decided not to move forward with this bill, not to make it into an act, and that is the reason president decided to withhold his assent. In 1954, President Dr. Rajendra Prasad withheld his assent to the PEPSU appropriation bill. Now what is this PEPSU? The full form of PEPSU is Patiala and East Punjab States Union. Actually, after independence in 1948, the princely states of Punjab, they all were merged together and they were together called as PEPSU, Patiala and East Punjab States Union. But later, after some time, these princely states, they were again merged into Punjab. So now we do not have this PEPSU. Earlier it existed. They were the princely states of Punjab. So what are we talking about? This is an example of absolute veto used by the president in 1954. And who was the president? Dr. Rajendra Prasad. It was about PEPSU appropriation bill. Then why did he use this veto power? The bill was passed by the parliament when the president's rule was in operation in the state of PEPSU. Now we know that in each and every state, the elected government is ruling the state. But sometimes when some situation arises where the president will have to rule the state directly, in such a scenario we say that the president's rule is applicable in the state. So what was the scenario? Earlier president's rule was in existence, but when the bill was presented to the president for his assent, the president's rule was revoked. Now we have seen something similar here also. Here we had seen that when a government's bill is passed by the parliament, but the government itself has been changed before the president gives an assent to that bill, then in that case the president can decide that he will not give the assent. And why does this happen? Because the procedure right from the proposal of bill to its passage is a long procedure. It is introduced, it is debated, it is passed in one house, moved to second house, then given to president for his assent. It takes a long time, and meanwhile the situation can change drastically. Like here what happened, the government itself has changed, and we see the same thing here as well. The president's rule was in existence earlier, but now the president's rule has been revoked, and that is the reason he decided that he will not give his assent since the scenario has changed entirely. Then another example, Again, in 1991, President R. Venkataraman withheld his assent to the salary, allowances, pension of members of parliament bill. Why did he do this? The bill was passed by the parliament on the last day before dissolution of Lok Sabha without obtaining the previous recommendation of the president. Again, the same scenario, government is going to change. It is the last day of the Lok Sabha. Now another Lok Sabha will come into existence, and moreover the president's permission or his recommendation was not considered before proposing the bill. Now if you look at this bill, it talks about salary of members of parliament, that is it talks about money, which means that it is not an ordinary bill, it is a money bill. And when it comes to money bill, the rules are different. We will see that later. But as of now, just understand that in case of money bill, the previous recommendation of president is necessary. So that is the reason he did not give his assent to this bill. And moreover, the government will change. It was the last day of the present Lok Sabha. And one more important thing that you need to note is these kind of examples are not to be ignored. Because in your UPSC prelims, you might get a question saying that absolute veto has never been used by Indian president. So that is a wrong statement. Or absolute veto has been used only once by Indian president. That is also wrong. So you need to have a look at all these examples carefully because these kind of questions are frequently asked in your prelims. Next one, suspensive veto. The president exercises this veto when he returns a bill for reconsideration of the parliament. However, if the bill is passed again by the parliament with or without amendments and again presented to the president, it is obligatory for the president to give his assent. Now, have we seen this earlier? Yes, we have discussed it earlier. Here, as per Article 111, whenever a bill is presented to the president, he has got three options: give his assent, withhold, or return a bill if it is not a money bill. And if the return bill is passed again with or without amendment and presented to the president once again, the president must give his assent to the bill. He doesn't have any other choice in this scenario. So this is what is known as suspensive veto. That is, he can suspend it only once. But if it is returned to him again, he doesn't have any other choice but to give his assent. This is nothing but suspensive veto. This means that the presidential veto is overridden by a repassage of the bill by the same ordinary majority. Now, what is this ordinary majority? Suppose the total membership of the House is 100. And if 51 members vote in favor of the bill, that is they agree with the bill, then you have got ordinary majority and the bill is supposed to be passed by the House. Now, what is this higher majority? Here it is written that in USA, if the president returns the bill to the House for reconsideration, the bill needs to be passed for the second time with a higher majority. That is, 51% is not sufficient this time because the president has asked you to reconsider it. Now you need more support. That is, more number of people should vote for it. Only then it will be passed. But in India, that is not the case. Again, if 51% of people agree with the bill, it is considered to be passed. And this time, the president will have to give his assent. He has no other choice. So that is the meaning of overridden by a repassage of the bill by the same ordinary majority. President does not possess this veto in case of money bill. We have seen that earlier itself. In the first slide, I have told you, if it is not a money bill, he can return the bill. So that is what is mentioned here once again. In case of money bill, he can either give his assent, withhold the assent, but cannot return the bill for reconsideration. Now here there is a high chances of making mistake because students might think that if the president doesn't have the power to return the bill, obviously he is not even allowed to withhold his assent. But that is not the case. Withholding his assent is allowed, but he cannot return the bill. Normally, the president gives his assent to the money bill as it is introduced in the parliament with his prior permission. Now, this statement I have already explained to you while discussing the absolute veto. The president chose to use his absolute veto in this case because it was introduced in the house without obtaining the previous recommendation of the president. See here, it is to be introduced in the parliament with his prior permission. So usually he gives his assent because he has already agreed to the bill, and that is the reason he will not reject the bill. Next is pocket veto. In this case, the president neither ratifies nor rejects nor returns the bill, but simply keeps the bill pending for an indefinite period. So that means he is not agreeing to it, he is not rejecting it, nor is he returning the bill for them to reconsider it and present it to him once again. So none of these things are happening. He is keeping it with him for an indefinite period of time. This power of president to not take any action with respect to the bill is known as pocket veto. That is, he is keeping the bill in his pocket without taking any action. The president exercises this veto power as the constitution does not prescribe any time limit within which he has to take the decision. Now, this could be taken as a loophole in the constitution, that is, it was not mentioned because it was understood that some action will be taken. Or it could literally be a power given to the president, that is, it is his choice to not take any action at all. We can take it both the ways. So that gives the explanation for the existence of pocket veto. It is because the constitution does not prescribe any time limit. However, in USA, the president has to return the bill for reconsideration within 10 days. Hence, it is remarked that the pocket of Indian president is bigger than that of the American president. Now, this statement is also a very important statement because I think a mains question was asked based on this, that Indian president's pocket is bigger than the American president's pocket. Comment on it. So, the answer is the pocket veto, and the reason is constitution does not prescribe any time limit. And one more thing that you need to note is, in this video, this is the second difference that we are seeing with respect to India and USA. First, we saw here, in case of suspensive veto, if the president returns a bill, second time you need a higher majority in USA, whereas in India, ordinary majority is sufficient. And then the second difference is seen here. In case of pocket veto, the Indian president's pocket is bigger than that of American president's pocket because there they have a limitation of 10 days. Example of pocket veto. In 1986, President Zail Singh exercised the pocket veto with respect to Indian Post Office Amendment Bill. The bill, which was passed by the Rajiv Gandhi government, imposed restrictions on the freedom of press and hence was widely criticized. After 3 years in 1989, the next president R. Venkataraman sent the bill back for reconsideration. But the new National Front government decided to drop the bill. In this example, we see that in 1986, we had a different president and a different government. And by the time we reached 1989, we had another president and a different government as well. In the first case, that is in 1986, the bill which was passed was curtailing the freedom of press. And that is the reason the then president Zail Singh decided to exercise his power of pocket veto. But when the next president came, he decided to send it back to the parliament since the government has changed and the new government can take its own new decision. And the new government decided that they will drop the bill altogether and will not move forward with it. That means President Zail Singh did not take any decision with regarding to this bill for a period of 3 years. That is 1986 to 1989. That is the reason we say that there is no restriction when it comes to the period. The president has no veto power with respect to constitutional amendment bill. Very important statement. We had till now seen ordinary bill and I have given you a gist of money bill. Now third type of bill that we are seeing is constitutional amendment bill. With the name itself, we get to know that it is a bill, that is a proposal made to amend the constitution. So, President cannot have a veto power when it comes to constitutional amendment bill. The 24th Constitutional Amendment Act of 1971 made it obligatory for the President to give his assent to a constitutional amendment bill. In case of ordinary bill, we saw that he can give his assent, withhold or return the bill. In case of money bill, we saw that he can either give his assent, withhold his assent but cannot return the bill. Now when we are seeing the constitutional amendment bill, here we get to know that President has no other option but to give his assent. That is, he cannot withhold his assent, he cannot return the bill. He will have to give the assent. And this was made mandatory by the 24th Constitutional Amendment Act of 1971. That is, originally it was not so, but it was made obligatory by a Constitutional Amendment Act in 1971. Take a note of this fact, very important statement. Now, since we have discussed the Constitutional Amendment Bill, I would like to bring to your notice one more point which we had discussed regarding Constitutional Amendment. And that was the ordinance which can do everything and anything that a parliament can do cannot amend the Constitution. That is, an ordinance cannot be passed in order to amend the Constitution. Apart from that, it can do everything that a parliament can do. Now, out of these four, we have already discussed absolute, suspensive and pocket veto. Absolute is withholding the assent. Suspensive veto, returning it, but it can be overridden by the legislature with an ordinary majority. Pocket veto, taking no action on the bill at all. Now there is one more called as qualified veto, which is not available to the Indian president, but it is available to the US president. Now this is similar to that of suspensive veto. In suspensive veto, we have seen that the parliament can pass a bill with the same ordinary majority and override the decision of president. But in qualified veto, when the president returns a bill, it has to be overridden by the legislature with a higher majority. An ordinary majority will not work here. You need a higher majority to override the decision of the president. So this is qualified veto, which is not available to the Indian president, but it is available to the US president. Now till now, whatever we saw was the presidential veto power when it comes to the parliament. But here we get to see that president has got veto power over state legislation as well. Why is it so? Because when a bill passed by the state legislature is presented to the governor for his assent, he has 4 alternatives. And this is given by Article 200 of the Constitution. What was the article related to Parliament? It was Article 111. So, President has got 3 options when a bill has been presented to him under Article 111. Then we had seen one more article, that was Ordinance, Article 123. So, Article 123, Ordinance, Article 111, the alternatives available to the President when a bill is presented to him. Article 200, the alternatives available to the governor when a bill is presented to him. So what are the alternatives? First one, he may give his assent to the bill. Second, he may withhold his assent to the bill. In the first case, the bill becomes an act. In the second case, the bill ends here itself. Third, he may return the bill for reconsideration of state legislature. So the first 3 are similar to the choices that the president has when he is presented with a bill. Now we have got one more alternative when it comes to the state legislature. The governor of the state may reserve the bill for the consideration of the president. Now when does this happen? Sometimes the governor is not sure about the decision that is to be taken with respect to the bill. In that case, when he is unsure, he will pass it on to the president and the president will take the decision. So that is the reason he has got 4 alternatives, and here again it is the same rule. He can return the bill if it is not a money bill. Now this fourth statement, that is the governor may reserve the bill for the consideration of the president. Because of this statement, the president has got veto power over state legislation also. The statement is very important. If you get this statement, do not get confused. The president has in fact got veto power when it comes to the state legislation. A bill passed by a state legislature can become an act only if it receives the assent of the governor or the president. Why the president? Because of the fourth scenario. When the governor is reserving it for the president, he is the one who is supposed to give assent. So when the president gives the assent, the bill will become an act. Now when a bill is reserved by the governor for the consideration of president, the president has 3 alternatives, and this is under Article 201. Here we saw Article 200, he is reserving it for president, and then the next step is what is the decision that the president will take. So the article is the next article, the next immediate article, that is Article 201. Again, easy to remember the article. So in this case, what are the options that he has got? He may give his assent, he may withhold his assent, or he may direct the governor to return the bill. That is, he will not return the bill directly. It was passed to him by the governor, so he will direct the governor to return the bill. Again, if it is not a money bill. So everything is similar, but there is a major difference. What is that difference? If the bill is passed again by the state legislature with or without amendments and presented again to the president for his assent, the president is not bound to give his assent to the bill. We had seen that in case of parliament, when the bill is returned to the parliament and the parliament passes it again with or without amendments and presented to the president must give his assent. That is, this time he cannot reject the bill, this time he cannot return the bill. This time he will have to give his assent to the bill. So this is one limitation which is not there in case of state legislature's bill. So there he has got absolute veto. The president is not bound to give his assent to the bill. This means that the state legislature cannot override the veto power of the president. Very important statement. Similarly, the other important statement is that the parliament can override the veto power of the president. That is true. And here in case of state legislature, it cannot override the veto power of the president. Further, the constitution has not prescribed any time limit within which the president has to take decision with regard to a bill reserved by the governor for his consideration. Again, there is no time limit and hence he can exercise the pocket veto. Here it is absolute veto and here it is pocket veto. But in case of suspensive veto, actually not a suspensive veto, because suspensive veto means that you can veto it once. You can suspend it only once but not the second time. But here he can suspend it even for the second time. He is not bound to give the assent. So this is more than having a suspensive veto power. So here, because of the unlimited time limit, the president can exercise pocket veto in respect of state legislation also. So do not get confused when you get this statement. Yes, president can exercise pocket veto in respect of state legislation because there is no time limit. Now let us compare the veto powers available to president when it comes to central legislation, that is the parliament, and the state legislature. So as we have discussed earlier, we have got 3 types of bills: ordinary bill, money bill and constitutional amendment bill. When it comes to ordinary bill, he can ratify it, that is he can accept it, he can give his assent, he can reject it and he can return it. Similarly, when a bill is passed by the governor to the president can ratify it, he can reject it and he can return it. He can ask the governor to return the bill to the state legislature. Second, money bill. Here, he cannot return the bill, he can ratify it, he can reject it. Same goes for a bill which comes from state legislature to the president. He can ratify it, that is accept it, he can reject it but cannot return it. Constitutional amendment bill, he can only ratify it, cannot reject it and cannot return it. We have already seen that it was mandated by the 24th Constitutional Amendment Act. Now when it comes to state legislation, a constitutional amendment bill cannot be introduced in the state legislature because amendment of the constitution is the sole right of the parliament and not of any state legislature. It can be done only by the parliament, and that is the reason this question doesn't arise at all. So that's all from my side for this video. I'll be back with the next lecture very soon. Thank you so much.